I got a lot of comment from people saying this is all cool, but what about privacy and data and stuff? So,
Absolutely.
you have
Mhm.
anything on that front that we could talk about?
Absolutely. So you were just speaking about the restrictions on citizens, and there is a lot of stuff happening which intersects and is interrelated. So the constitutional restrictions on our freedom of speech run into saying anything which affects the sovereignty of state, the security of the state, friendly relations with other states, if it affects public order, if it defames, if it's about contempt of court, if it is affects morality or decency. And the reasons why these were put in was because when India becomes independent, uh, free speech isn't, of course, free. There have to be certain guidelines. Uh, the constitution itself is drafted through partition, so matter we've had a massive displacement of population, and uh, to make sure that in a very volatile situation, speech is not does not become disruptive to public order. So those are the constitutional guidelines on restrictions on the freedom of speech. But at the same time, with the introduction of the internet, a lot has changed since then. So one of them, of course, is the fact that we do not, in fact, have a data protection bill. So maybe some of the comments to your Digiyatra were related to that. But in 2021, so the major statute which regulates what we information transmitted over the internet is the IT Act 2000, and it does not sufficiently protect personal data. There is a bill at the moment pending in Parliament, the Digital Personal Data Protection Act, and it does, in fact, try to protect personal data. But we'll come to that in a little bit about how it does that. But first, can we just talk a little bit about the IT Act, because I think that's a little.
Yeah, please. Sure.
So the Information Technology Act is an act which regulates what we say. But so let's start. So three. I'd like to look at three sections. The first section I'd like to talk about is Section 66A, and it says that anyone who transmits or publishes anything which is offensive or annoying can, in fact, be arrested and convicted for up to 3 years. And this was an amendment by the Congress government. But the point I'd like to reflect upon is that the distinction between the word transmitted and published. So if I do, in fact, share a private message, it would, in fact, be covered by transmitted. However, it is not, in fact, being published. So, these two words tend to obfuscate. So, what is publishing in legal terms means something which is known to the community. So, there is a certain distinction there if I'm sharing a private conversation with a friend, emailing somebody, or versus putting it out on Instagram. 66A, however, was struck down by the Supreme Court when it was found that because of its very vague wording, that if anything is offensive or annoying, uh, it can result to a penal consequence of being arrested and convicted. So it was struck down. However, there's also this gap between what the Supreme Court decides and what actually happens. So the Supreme Court may have struck it down, but 66A is still, in fact, being used to harass, convict people. So that's the first section, which just highlights how we, in fact, need a data protection, a personal data protection act, which focuses on consent and privacy rather than what is being transmitted.
Yeah.
The second two sections also relate to this. So section, I just want to, 1 minute. Could you give me a minute? Yeah. So again, when it comes to privacy and consent, Section 67 again looks at publishing and transmitting anything which is lascivious or prurient, and this echoes the language of the Indian Penal Code, specifically Section 292, which is the obscenity clause. That if you publish anything obscene, then you are, in fact, liable in court. But again, the point over here is that transmitting something which is lascivious or prurient is not because it is violating the person's privacy or consent, but it is, in fact, what's happening out there. And 67A, so 67 and 67A are, in fact, still on the statutes. make you criminally liable if you share something which is sexually explicit. But so there have been a couple of cases where somebody's put up a video of his girlfriend, which was taken. Now, again, the question of consent is not important here. The point is that he just transmitted it, and that makes him
Yeah.
criminally liable. So these are the important sections which I think we should know about, because one can run into trouble, and one should be aware of these other clauses. And because these are so wide, I'm sure many of us might have in fact already committed, if you share a picture of yourself, so just transmitting a picture become makes one criminally liable. Yeah.
Two things you said about this, right? One is the term annoying. Like, I'm sure
Yeah.
that's like super vague and super subjective, right? Like, I see 10,000 annoying things every day on the internet,
Mhm.
annoying to me. And
Absolutely, yeah.
when you say explicit, right? That was the term you used.
Right, yeah.
Nudity and sexuality, I think, is very straightforward to understand. But what all does explicit encompass?
uh I wish I was an authority to
But this
describe
is
that.
vague, but it's a full.
It is, but there was a recent judgment where the court said it had to be actually explicit, which again really didn't describe. But I would assume they mean the sexual act. Um, but like I mentioned, the concern over here is not about the violation of somebody's privacy, but the concern is more about the impact on public order and these images being shared. And the whole idea of something being lascivious was that if you see something pornographic or if you see something sexually exciting, one is going to not be in a temperate state of mind. And this was a very colonial idea that sexuality should in fact be curbed, and you should not be titillated or find anything scintillating, because just the merely looking at something is enough to s- s- m- m- uh, make one akin to a crazed person. Again, these are fairly outdated ideas and fairly Victorian ideas, which continue to shape our free speech. Yeah.
So just to understand, if someone took a picture of themselves, which is slightly questionable, and sent it to, let's say, their partner, uh, that is breaking the law.
I'm going by this, yes, because you are transmitting it, and I think the point that it is being transmitted itself makes one, question: is transmission enough for it to be affecting public order, or for it to be? But I think the concern I really don't know why this was put in. I'm not competent enough to say that, but yes, it would, in fact, yeah. So, yeah, so one sees that this boyfriend who was convicted for uploading his girlfriend's pictures was convicted under this particular section, but the girl's privacy and consent was not even considered, which takes us to the fact, where is privacy within our constitution, and why wasn't privacy made a fundamental right? And interestingly, when the constitution was being drafted, a communist member of the Constituent Assembly, Somnath Lahiri, brought this up, and he raised the question: Does the state have the right to, in fact, intrude my home, come in, search my papers, and we need to have a clause about this? But eventually, the decision was made not to, in fact, have an explicit right to privacy. Fascinatingly enough, in the evolution of American jurisprudence and constitutional law, it was the Kodak camera which
Okay.
alarmed many people. So the Kodak camera is invented in the late 19th century, and the fact that everybody had this camera and was busy taking pictures really alarms these two lawyers, Samuel D. Warren and Louis Brandeis. And it is in 1890 that they write an essay called A Right to Privacy, and they define privacy as the right to be left alone, because they're alarmed about technology. So there is a clear interface between technology, surveillance, the Aadhaar card, biometrics, and how it can violate our privacy. And when we think about privacy, it is not just the sense of being left alone, but it is also a spatial thing. It's a physical space, and it's a relationship, so a private relationship. And the underlying understanding is that if there is a violation, that violation is permissible only if there is consent.